We've talked about your seating and whether you were comfortable. I'm wondering how each of you is doing, because I would like you to be able to stand if that would help. And, after today, we can switch your seats. That would help.
I don't know if that would help. Yeah.
Okay.
I think I'm okay. I just get really stiff. It's kind of getting up and down. So one position is fine. Thank you.
Okay. All right. Now, there's a problem with the light, and I know during number 2 and 7 there's glare, and it's the backlight.
No, it's just one overhead. It's driving my contacts out because it's right in my eyes. But I'm going to switch to glasses tomorrow. I'll probably be fine.
All right, but we also, Deputy Washington and I were talking about the situation. After you all leave, we'll get up there with a ladder and
Just unscrew the light.
we do unscrew the light bulb. So
That's a joke. I'm a lawyer.
okay. I can tell lawyer jokes. I wanted to talk to you also just because we are obviously it's a public place, and we know about coronavirus being a problem, sort of a threat that's out there, and I want to make sure, for your own sake, but also for the sake of our process, I mean, I'd like you to all stay healthy. And our court has communicated, is working with the Los Angeles County Department of Public Health, and they work with the Center for Disease Control. So let me remind you of some just advice for everyone, anywhere, but particularly here. It is important that you continue these prevention measures. Wash your hands briskly and often with soap and water for 20 seconds, especially after going to the bathroom, before eating, and after blowing your nose, coughing, or sneezing. Cover your cough or sneeze with a tissue and then throw the tissue in the trash. Immediately wash your hands. If soap and water are not readily available, use an alcohol-based sanitizer with at least 60% alcohol. We have a sanitizer now on the round near you so that you can have access to it if you need it. Stay home when you're sick. Call us if you're sick. You're sick, and we'll take the day off. Whatever it takes, but you will. No, you have to come back. We'll wait for you. You must stay home if you're sick. Avoid close contact with people who are sick. Avoid touching your eyes, nose, and mouth. Clean and disinfect frequently touched objects and surfaces using regular household cleaning spray or wipe. Prepare for disruption by stocking your home with food, water, medicine, and other emergency supplies. So, but I do really want you all to stay well. Just thought I'd remind you that it's good practice. And a juror had a question about asking questions. I'll talk with you about that a little bit later. Not during the opening, but we'll talk a little bit later about if you should have a question, what do we do? Generally, you'll write a note, and I will share it with the lawyers. I don't have jurors ask questions. But if there's something you're concerned about during the presentation of evidence, that's what you would do if you had such a question. So with that, let's proceed now with the balance of the opening statement from the people.
I was rushing right before lunch, and I just wanted to go back to slide two. So I want to be clear. So when Mr. Durst was arrested, which is going to be back on, I believe, October 8th, he was arrested, and in the back hatch of the Honda CRV was again this unused bow saw. Now, when Mr. Durst testified, and I screwed up because I didn't let it run as I should have. Mr. Durst made very clear that he had purchased the bow saw in New Orleans, and what he described was the following. He said that as he was driving to New Orleans, he decided he wanted to get rid of the car. So about an hour outside of New Orleans, he pulled off on a logging trail, started driving the car up on the logging trail, and then he came across a tree stump in the road. So he decided, can't get past this tree stump, apparently too heavy to move. So he turned around, drove another hour to New Orleans, where he then bought the saw, and then after all that decided that no, he was going to drive the car back to Galveston. No testimony that there was anything special about the log road, or that he didn't look for another road, or that he didn't dump the car any other place. So that is the explanation as to why he had this bow saw unused in the back of his vehicle. Now I'm going to get to it as we progress, but we're going to present evidence as to what that bow saw was going to be used for, and it was not for cutting up a tree on a logging trail. Now, on October 9, 2001, when he was arrested, he was charged with Moore's Blast murder.
Are you clear?
Well, we've had actually, for one of these presentations, not a whole lot of problems. So this is kind of our first one. If you give me a moment, again, I apologize.
How we build up suspense.
Oh, you know what?
It's not bad.
No?
No.
I was arrested in Galveston. I spent one night in prison in Galveston. And I had been told by the detective that you've been charged with murder. Bail has been set at $250,000. And I didn't think that when you were charged with murder, I mean, I didn't know nothing, but you can't give someone charged with murder or bail because they're going to run away, of course. Went through my mind. And I said, it's $250,000? And he says, yes, it's $250,000 cash. So I said, how do I go about doing this? He looks at me and says, do you have $250,000? I said, well, not on me.
The evidence is going to show that the Galveston police knew who Bob Durst was. They knew what his name was. They did not know who Bob Durst was, and that he was a very, very wealthy man. Mr. Durst expanded on this, again, in the interviews with Mr. Jarecki, and made very clear that, you know what, if once he was getting bail, he was never coming back.
But was your intention when you put up the $250,000 to run away?
Oh, goodbye $250,000, goodbye jail, I'm out.
Did you think to yourself at that point, well, sometimes these things, you know, they don't, it's not like a quid pro quo. If you give them the $250,000, you forego the jail time. Sometimes you have to do both. You know.
This is bail. You bail yourself out, you're out.
But you have to come back at some point.
Yes, yes, you sign a bunch of papers about coming back on a certain time. I didn't care what I signed, I wanted to get out, to get the $250,000.
Did you, when you signed the papers and things, were you thinking to yourself, I'm going to leave and I'm not going to come back unless there's a...
Yes, yes, show me where to sign, where do I sign?
But your intention at that point was simply to get lost, to go away. It
Run
wasn't...
away, I'm not going to stay here and face murder charges in an unwinnable murder case like the... I mean, especially, they got me on my neighbor being shot in the face with my gun in my apartment, which I rented, disguised as a woman, and I dismembered the guy's corpse. Who's going to acquit me? I'm obviously guilty in front of the eyes of the world. I'm guilty. I ain't coming back here. I'm never going to see this place again.
I want to be clear on something, what the evidence is going to demonstrate. At the time Mr. Durst is making these statements about Morris Black and about the trial, it's 2010 and 2012, and then again in 2015. He's already been acquitted in Galveston. He cannot be prosecuted. So when he is saying these things that many of you might view as incriminating, remember, he knows that that's already done. Now, the morning after his arrest, Mr. Durst posted bail, posted $250,000 as he discussed. And as he told you in the last clip, he skipped bail. Now, the evidence is going to show that Mr. Durst was so unaffected by allegedly unintentionally killing his friend or killing him in self-defense that he literally takes Morris Black's driver's license and he uses it to rent a car in Mobile, Alabama. So after he kills Morris and dismembers him, he has the state of mind to go back and get Morris's information to assume his identity, and that's exactly what he does. Now, while on the run after he skipped bail, Durst checked into numerous hotels throughout the country using multiple different aliases. Emilio Vignoni, Maury Block, all individuals from Mr. Durst's past life. Now, in an effort to hide his identity, Mr. Durst shaved his head and eyebrows. And I want to be clear, there have been, again, in various publications, crazy theories about what he was doing and why he was doing it, etc. It's very simple. Mr. Durst shaved his eyebrows and he shaved his head because he was trying to disguise himself. No different than what he was doing when he was pretending to be a mute woman. Now, on November 30th, 2001, after 45 days on the run, Durst was arrested in Pennsylvania at a Wegmans, which is a kind of like, I guess, maybe the Bristol Farms of Pennsylvania, or maybe the Whole Foods of Pennsylvania, for shoplifting a chicken sandwich, a newspaper, and Band-Aids. Now, at the time, Durst had about $500 in his pocket. He had $37,000 inside his car in the parking lot. This is the video of the actual shoplifting. There's Mr. Durst. There's him putting the stuff in his pocket. Now, in Durst's rental car, police would eventually find 2 loaded handguns, additional ammunition, marijuana, and Morris Black's driver's license. Inside the car, investigators made another startling discovery. They found this Meade 5-star notebook. Inside that spiral notebook was this notepad from a hotel that Durst had stayed at in Danbury, Connecticut. That information that you see, that was Gilberta Najami, Kathie's friend, a very outspoken individual about Mr. Durst's guilt involving the disappearance of his wife. And Bob Durst had her address, the name of the place she worked, and her home phone numbers. They also found a Fairfield County, Connecticut atlas. Now, this is the county at the time where Gilberta Najami was living. Now, in Durst's rental car, police also found...
No, this is Andrea Potter. As I reported exclusively Wednesday, authorities believe Douglas Durst wasn't the only person on his brother's hit list. When Robert was picked up in Pennsylvania along with 2 guns, ammos, and wads of cash, his trunk contained directions to the Connecticut home of Gilberta and Jamie, a friend of Robert's missing wife, Kathie.
I don't know who concluded that.
Did you have this address of Gilberta and Jamie's?
No.
You didn't have it. You weren't going to go do something back.
I have no idea where she lived. Where she lived then or where she lives now.
Now, the evidence is going to show that, again, although Mr. Durst is oftentimes very free with very damaging and uncomplimentary information about himself, it will also be demonstrated that he will bold-faced lie about information that you know, that you've already heard, is untrue. That was Mr. Durst saying that he had no information about Gilberta Najami. You saw what was taken from the car. Now, the car contained some other information as well. They found a note that was directed at Durst's brother Douglas. It says, "What DD is doing to me puts me in the same place as what Kathie did to me." Now, a couple of weeks later, while in custody in a Pennsylvania jail awaiting extradition, so what happens is Mr. Durst is arrested. They discover who he is. And when this happens, they end up finding a warrant. He lies about what happened, lies about who he is, but eventually they find out who he is, and now he's going to be extradited back to Texas. So while awaiting extradition, Mr. Durst is in custody, and he makes a series of phone calls. You're going to hear jail calls from Mr. Durst. Mr. Durst likes to talk on the phone from jail, and he will say things that are oftentimes not very helpful. Now, this is true even though Mr. Durst was told, and it says that these calls are being recorded. So Mr. Durst is in jail. He's talking on the phone, and he expanded on the plans for his brother Douglas in a conversation with his wife.
And do you remember what I told you the other day about when we were talking, what I said I thought you were going to do? Remember?
No.
We were talking, you were telling me about what your life has been like and what you were thinking.
Yeah, my plan is, yeah,
Okay?
definitely not gonna say it.
Okay, but you told,
I think this is in violation of code number 1101A. And I want to object to it.
Overall? Go ahead.
You need to start it over. Mr. Garrett, if you don't
No,
know.
I apologize.
No, I want to let Mr. Garrett.
Wait,
When-
I'm sorry, you can't see me, David. You should pause.
When
Yes?
there's an objection in the middle of Law&Crime, that's when I have to, there's no way for me to start in the middle, I have to start the slide over. That's what I want to done.
Yes, that's what you must do.
I did. Yeah. I believe I just said this, but the evidence is going to show that DD stands for Douglas Durst, Bob's brother.
and do you remember what I told you the other day about when we were talking, what I said I thought you were going to do? Remember?
No.
We were talking, you were telling me about what your life has been like and what you were thinking.
Yeah, my plan is, yeah,
Okay?
definitely not gonna say it.
Okay, but you told me what your plans were, well, and I told you that I knew, I had a feeling, I suspected. Remember?
And I certainly screwed it up, didn't I?
Well, never mind that, but if I suspected, he too suspected. What I'm trying to say. You didn't really focus on
Well,
it.
something I think I left this house, and I'm telling you that I went to his Corona house while I was in Danbury.
I think I read that you did, but I don't remember if you told me.
You read somebody's, I think I told these, the Mike Kennedy types that I was driving around these places, I grew up, my family places, and
Oh, it was in the newspaper then.
yeah, but I really went. The next time we have a visiting day, I'll go over it with you.
I'd like to hear it, but...
I sort of left that out.
Okay, but I just want you to know that, remember what I told you, I thought you were going to do? He knew it too. Keep that in mind.
I think that if he was concerned about that, he wouldn't have been treating me so bad.
I disagree.
What?
I don't agree with you. Treating you
Because
pretty
he
good.
thought I would screw it up like I did. Maybe he's right. I guess he is right then.
But, you know,
If you're right,
remember that if I knew it, he knew it. That's my point.
This is Mr. Durst talking to his wife. The evidence is going to demonstrate that the person they're talking about is Douglas Durst. The plan they're talking about is Bob Durst killing him. Bob Durst is saying that he screwed 1101. February 27, 2002, Bob Durst was extradited to Galveston to stand trial for Morris's death. On March 29, 2002, New York Magazine published an article titled, "Did Bobby Durst Put It in Writing?" by Lisa DiPaolo. Lisa DiPaolo is a writer. You're again going to hear testimony. She previously testified. We have a stipulation. It's going to come in. We're going to play it. She's not going to be live. Now, this was the first mention in the media. So we're now, this is March 29, 2002. This is the first time that the cadaver note was ever mentioned in the media outside of law enforcement. Now, the article also discussed the misspelling of Beverly. DiPaolo made clear in the article that she had seen a copy of the cadaver note, compared it to Durst's writing, and noted that it looked like they matched. So this was an article that was widely distributed. The circumstantial evidence in the case demonstrates that as of the publication of this writing, Bob Durst was now aware that the cadaver note was being directed back to him. Now, on April 26, 2002, Galveston trial judge Susan Chris ordered Durst to provide a handwriting sample to LAP investigators. Now, this is while Mr. Durst is awaiting trial in Galveston. So he's awaiting trial, he's in custody, and there's an order that said, hey, you have to provide handwriting samples. Now, on April 30th, 2002, this is a little bit before the trial started, Durst provided the handwriting samples as ordered. Retired Detective Paul Coulter is going to come out here and testify. He was present when those samples were produced. He's going to tell you that he watched Bob Durst write very slowly and deliberately. He says as he was watching, it was clear that the way Mr. Durst was writing appeared to be an effort to disguise his writing. At one point, Mr. Durst literally started writing from the bottom of the page upward. Now, as is the rule in every criminal case, the prosecution team in Galveston has to turn over to the Durst defense team prior to trial evidence that investigators had collected. Now, it is at this time, while awaiting trial, that Bob Durst puts together the BD story. So remember, he and his attorneys have been provided with the information that the prosecution has. And that's when he authors the BD story. Now, the evidence will show that the BD story would basically form a template for his Galveston trial testimony. At the top is the BD story, at the bottom is the Galveston testimony. I'm not going to go through them now, you're going to have them both, but they're very, very similar.
What was the basic idea?
Mr. Durst is going to be asked, in essence, what was the plan for how he was going to deal with the charges in Galveston, and this was his response. Remember, this is taking place in 2010. This is 7 years after the trial and after he's been acquitted.
What was the basic idea of how you were going to get off in Galveston, if you were?
How I was going to get acquitted, what my story was going to be, what my case was going to be. The best case was immediately, I mean, the other lawyers who came to see me, Mike Kennedy was a well-known New York criminal lawyer. He was sure I had to plead temporary insanity. My sister was still there for me. She was standing up for me, and she brought in Mike Ramsey, who brought in Dick DeGuerin. Mike Ramsey was a real pain. He was sure I had to plead temporary insanity. They're never going to believe your story. You have to be insane. Only insane people dismember corpses anyway. But I came to meet the other lawyers. Lawyers were calling, lots of lawyers, big case. Lots of lawyers wanted to take it. And Dick and Mike, Dick DeGuerin and Mike Ramsey knew what Mike Kennedy did not know, because Mike Kennedy's a New York lawyer, they were Texas lawyers, that self-defense is a very viable plea in the state of Texas. In the state of Texas, you find somebody in your house who's not supposed to be there. There's not much you cannot do to them. Most other states, what you're obligated to do is to call the police, do something else. You're obligated to leave. Texas, you're not obligated to leave. You can handle it more or less as you see fit. Obviously, you're not supposed to kill them. But you can, but there have been cases where people have seen guys in their garage, and look, this has got a lot of publicity, and shot them from distance with a rifle, and they put it in self-defense. And Dick and Mike both knew that self-defense was a very viable plea in the state of Texas and the state of Alaska and a couple of other states, but that was it. And I should go through it in detail, and it was explained to me that I was going to have to do the dismemberment. There was no way around it. But at the same time, the dismemberment happened, and both Mike and Dick came up with this independently, because they hadn't come to me as a team, they'd come to me independently, that the dismemberment has nothing, should not have anything to do. The judge should separate the dismemberment from the death of Morris Black, because the dismemberment did not cause his death. And that was them listening to my story. The indictment says that he was dismembered, he was killed by being dismembered. And I did not kill him by dismembering him. I dismembered him after he was dead. And they were sure that if I was telling the truth, which they had to believe because the alternative was to not represent me, that the judge should separate to a large extent the dismemberment from the death of Morris Black. Yes, the DA would be able to bring it up, and yes, you would have to talk about it, but the dismemberment did not cause the death. And therefore, they put in front of the jury about 1,000 times, was there anything that Robert Durst could do after finding Morris Black dead to prevent his death or to change the manner in which he died? And they brought up about a zillion examples. Can you unstrike a match? No. Can you unring a bell? No. If somebody's dead, is there anything you can do to prevent him from dying? No. And that was the case. They said that would be the basis of our case, but you're going to have to testify. You're going to have to testify truthfully. You're going to have to do real good. This will be very, very unpleasant. It's a very difficult case. But Mr. Durst, you're not definitely going to lose like they say in the newspaper.
Opening statements in the murder trial began on September 22nd, 2003. As was its right in that trial, and again, a defendant has a right to testify, and they have an absolute right not to testify. Mr. Durst in this trial elected to testify. He was asked, again, 7 years later approximately, whether he had been truthful with the jury in Galveston. And this is what he said.
At the time, you certainly said to me that you did lie to the jury in Galveston in some way, that your lawyer encouraged you to. And I think that's...
He didn't encourage me to. We went over the oath. And from day one, the oath says, you promise to tell the truth, the whole truth, and nothing but the truth. Just make sure that the ones at the end tell the truth, nothing but the truth, that you do exactly that. In terms of the whole truth, if you want to leave out something that does not, which makes you look bad if you tell it, but does not turn into an untruth, well, try it. Try it. If there's something so terrible you don't want to say it or you think could be construed the wrong way, then just leave it out.
Now the evidence will show that during his testimony, Bob Durst lied. He lied about Kathie's disappearance, he lied about his whereabouts at the time of Susan's murder, and he lied about the true facts concerning Morris's killing and the dismemberment. Many of these lies will be disproven during our case. Now, Durst testified that when he entered the apartment, he saw an angry Morris sitting at the table. He alleged that he then went to the oven to look for his .22 pistol that he had hidden there. By the way, before lunch I called it a 22 millimeter. I don't know what I was thinking when I'm doing it. It's obviously it's .22 caliber firearm. It's a 9 millimeter. In the event, Durst alleged that he then went to the oven to look for his .22 pistol that he had hidden there. He testified that upon finding the oven empty, he repeatedly demanded of Morris, "Where's the gun?" Durst then testified that Morris reached under a jacket on the table and pulled out the .22 pistol. So according to Mr. Durst's testimony, Morris Black had already retrieved this gun and was hiding it. Durst alleged that Morris then turned toward him armed with the pistol. Durst testified that he grabbed the barrel of the gun. He testified that he and Morris fell to the ground and that the gun unintentionally discharged, shooting Morris in the face. Now, the only evidence that you're going to hear in this case that that version of events is true comes from Mr. Durst himself. Physical evidence is not going to support it. Now, in advance of the trial...
Excuse me, Your Honor. The argument with the physical evidence, I object
back to the slide.
Okay, I'm sorry, I looked away, and so I missed that part. Go ahead.
Oh, thank you, Your Honor.
Repeat it, and I may, I'll hear what you say, and I'll consider the objection.
What I said is that the only evidence this version is true is going to come from Durst himself. The physical evidence in the case that the people are going to present is going to impeach his version of events.
Just for the record, that's not what he said.
I don't think that's an
Okay, I'll
objection.
check the record.
Your Honor, the court's rule on speaking objections is that.
I don't want speaking objections, but he was actually helping me find the.
Can we also designate, please, one lawyer who's supposed to be making objections?
Yeah, I don't want to hear 10.
I apologize, Your Honor, I won't do it again.
Overruled. Go ahead.
Thank you.
First sidebar.
All right, I don't like those sidebar, but it seems I need to.